Thank you so much for joining this webcast today. I'm Pat Soldano, President of Family Enterprise USA. We promote generationally owned family businesses and their lifetime of savings. We work with all industries and all sizes of business. We're very pleased to have South Dakota Trust Company join us today for this webcast. As you can see from the title, it is Powerful Trust Designs and Structures for Family Enterprises, the Need for Flexibility. In this webcast, we will discuss modern trust designs and structures that provide families the flexibilities needed to deal with uncertain futures. We will discuss various types of trust structures, including third-party trusts and self-settled trust. Additionally, we will cover directed trusts and the trust designs available alongside them in the boutique trust states. South Dakota Trust Company, LLC, is a national boutique trust company founded by Al King and Pierce McDowell and headquartered in Sioux Falls, South Dakota. Currently, South Dakota Trust Company has more than $135 billion in assets under administration and $82 billion under agency. I'm very pleased to have with me today three speakers for our webcast. The first is Jim Paladino. He is President, Executive Managing Director, and Chairman of the Management Committee, and President and Direct Managing Director of South Dakota Planning Company in New York City. South Dakota Planning Company, and all of our speakers today are from that organization, is an estate planning and trust advisory firm for the wealthy. It is responsible for sales, marketing, and technical support, including speeches, publications, trust planning, and consulting to support South Dakota Trust Company, which, as I already mentioned, is headquartered in South Dakota. Mario Nori is Managing Director and Corporate Counsel of South Dakota Planning Company in New York City. And Will Murphy is Managing Director of South Dakota Trust Company Planning and is based out of Westport, Connecticut office. So, gentlemen, very nice to have you with us today. I think this is going to be a very interesting conversation for those that have joined us today and for those that will view it later, as this call is being recorded and it will be posted on our YouTube channel for anyone to view. So let's just get started, and I'm going to turn it over to Jim for that.
Well, thank you, Pat and Lauren, and Family Enterprise USA for having us here today. We're excited to be here. Just another quick note on South Dakota Trust Company. As Pat said, we are a state chartered trust company, and we're regulated by the Division of Banking in the state of South Dakota. We have clients in 47 different states, so all of our clients come from all over the U.S. and they can have a trust like we're going to talk about today in South Dakota. What just makes us a little different, and I think especially relevant to all of you here at Family Enterprise, is we don't have any investment services or products. So when we act as trustee, and as Will and Mario are going to talk about, especially in like a directed trust, we work with the family and the family members on what assets are held in those trusts. And for a lot of our trusts, for a majority of our trusts, it's a family business. So we're going to talk about some of the trust designs, but understand that most of the structure we're dealing with, the asset, it can be an investment account, but for a lot of it, it's some type of interest in a family business. I think as I read on your website, Pat, which was great, over 87% of businesses are family owned in the U.S. So, and as your group has said, you're promoting, business creation, business growth, viability, and sustainability. I think where that falls in with us is, estate planning, and how are we going to protect the business? How are we going to make sure that the business stays effectively in the family, if that's the goal of the business owner? So we're going to discuss today different trust structures, different trust designs to help protect and to keep that family business in the family. As we know in the world today, there are so many uncertainties, and those are the things we need to plan for. So if we look, on our first slide here, the important future uncertainties for any family enterprise come into 6 or 7 different scenarios. First we have the family. Certainly uncertainty with, are there children in the business or they're not children in the business? Now, these days, especially, we're dealing with different generations. And, we have owners that are baby boomers or Gen X. We have next generation that are millennials or Gen Z even now. And we know each generation has different sensitivities, different attitudes, different roles, and different ways that they're looking at that family business. So when doing planning, we need to take all of those different iterations and different attitudes and different sensitivities into play. So a lot of uncertainty when we're dealing with families. How can that be helped with some of these trust designs? Certainly economic uncertainties. I know now you're looking at, where's the availability of capital? What are interest rates going? How is the overall economy doing? Is it going to be up? Is there going to be a recession? Certainly an uncertainty for any family business that needs to once again plan for in the future. We have political uncertainties. Next year is an election year. Depending on where things are, different policies and maybe beneficial for some groups or detrimental to others. So how does that affect your family enterprise? And is there a structure that can be put around that to help protect what's there? As we know, asset protection, I think, is a huge concern for all of us. As we know, the U.S. is one of the most litigious countries in the world. There's so many things we get sued for. Sometimes just the cost of being sued is a lot. So we need to protect against litigation, to protect the asset. And then there's also as divorce. As we know, 30–40% of marriages in this country, can end in divorce. And with a family enterprise, that comes, can affect us in so many different ways. Are there in-laws involved? Where's the ownership of the business? Are there settlements that need to be had? Once again, where does trust design come into that? And Mario's going to talk a bit about that specifically. And then we always have taxes. We have income tax. So we have federal income tax, state income tax. When you're in lovely New York City here, you have city tax. So you have income taxes to look at. But we're also going to look at transfer taxes. So that's estate taxes, gift taxes. How can we efficiently transfer assets so that once again, they're protected against some of these uncertainties from family, political, and asset protected. Right now, I can tell you the exemption for all of us is $12.92 million or $13 million per person. So almost $26 million if for a couple. That's a nice amount. But what I can tell you also is this is due to end December 31, 2025. That's not that far away. I used to think it was far away, and now I look down at the calendar and I'm already into January of 2024 when I'm looking at scheduling things. So by December 31 of 2025, that exemption is going to go down to about $13 million per person to $5 to $7 million per person. While it's still a significant amount, it's going to be almost half as much as it is now. So that'll be a big change. My advice right now, start planning now, because the longer you wait, the longer we saw this similar change in 2012, and people who wanted to do planning back then, lawyers, and people who wanted insurance and people who needed an EIN number or tax identification, all that got very difficult to do for people who waited. So big advice right now, start thinking about it, start planning, because there will be a change at the end of 2025. Then there's certainly other uncertainties. I looked down at that, who would have thought COVID could change the world like it did? What is artificial intelligence going to do? How is that going to change all of our worlds? Looking at, lawyers, will it change the lawyer's job? Will it change anything with you do within your family enterprise? And how will that come into play? Climate change, we have family enterprises that, may be affected by some of the things going on in that arena. Whether it's something, once again, it can be a positive effect or a negative effect for all of these uncertainties. The thing that scares me the most these days is certainly the uncertainty that I can't even think about now. Like I said, I'll go back to COVID. Back then, who would have thought that would have changed kind of what we do and the world so much? So these are the things we're looking at these are the things we're going to look to talk to you about. So our goal is to provide you with trust structures and trust designs for family enterprises to provide you and your family the flexibility to deal with these uncertainties. So I'm going to start by turning it over to Mario.
I appreciate that, Jim. And can you hear me just in case? Yeah. Okay, great. So I think it's important before we start actually talking about specifics and trust design is to take a high level view of what the heck we're even talking about, right? So, we look at an irrevocable trust in this type of planning that we see. Not revocable trust, that's another portion of it. But what we're going to talk about today are mostly irrevocable trusts. And when you break it down, you can really see it in two big buckets, okay? You have third-party trusts and you have self-settled trusts. And we feel calls all the time, right, from families across the country and even the world. And the amount of confusion with all these terms of SLATs, domestic asset protection trust, dynasty trust, all that is so confusing, even for me, who does this every single day, that at the end of the day, you can really put most of this into two buckets and really a lot of it into one bucket. And that's this third-party trust, right? A third-party trust is what you and I are thinking about when we're doing trust, or what we traditionally think of as trust. I'm setting up a trust for my son or for my grandkids, the third party being those other people. I'm the grantor, the settlor, and I'm setting up a trust for these people. And that's what common law, and you go back to the English, that's what this is all around. And all 50 states have laws around this. And so that's third-party trust. A self-settled trust, on the other hand, is I set up a trust, and I can set it up for my children and my grandchildren, but I can also be a beneficiary of that. And that's, a revolutionary concept. Before 1997, first state being Alaska that actually enacted this statute, and then followed by South Dakota, Delaware, Nevada, Wyoming, these boutique trust jurisdictions that you'll hear throughout this conversation. It was like taking money from my left hand, or my left pocket rather, and putting it in my right pocket. There was no fundamental difference between a self-settled trust and, say, a revocable trust. None. I don't get any asset protection benefits. I don't get any tax benefits, estate, gift, income, nothing. It was like you could do, it was like taking money from left to the right. And so in 1997, that changed. And so these state laws that started to come into play allowed for grantors or settlers to have, or to be allowed to be beneficiaries and still garner the benefits of a trust. The bulk of the planning that you will see will be in that third-party trust world. But you shouldn't forget that self-settled trust world also applies. And I bring it up a bit now because with asset protection, there's a lot of conversation about domestic asset protections, trust, or DAPTs, or asset protection in general. But both self-settled and third-party trusts provide for asset protection. And so if you look at our next slide here, all 50 states provide for a spendthrift provision. In fact, if you have a will or a trust, I'm willing to bet you $1 United States dollar, there's a clause in there that says the beneficiary of this trust or this will can't assign their interest, can't transfer it, can't sell it, and a creditor can't attach to it. And so when you talk to a lawyer or an advisor, they'll often point to this and say, don't worry, you've got asset protection. We've got a spendthrift provision in there. And they're right. But, and there's always a but, there are exception creditors depending on what state you are in to that spendthrift provision. So depending on what state you're in, say a California or Florida, which has got some negative case law and provide for exception creditors, your spendthrift provision may not actually provide you protection. And that's to these third-party trusts too, which is pretty shocking to a lot of people because say you set up a trust for your children. In some states, if they get a divorce and there's a divorce judgment for alimony, that spouse, I set it for my daughter, she gets married, bad dude commits all these bad things, may have a right to this trust now, depending on what state that is. So if you go to these boutique trust jurisdictions like South Dakota, they've actually put in legislation that says specifically that there are no exception creditors to our spendthrift. It's against our public policy. I mean, they codified that. And that is incredibly powerful when you think about it. And it's something to consider while you do your planning, right? Or if that's a consideration for you or something you're concerned about, you should think about that. And there's another form of asset protection that we'll see on the next slide here in discretionary interest. And this gets kind of complicated, but what effectively it means is discretionary interest is I'm giving a trustee a decision to distribute out money. So say I set up a trust for my grandkids. They come asking for money for a house, a yacht, start a business. That discretionary interest, so that decision by the trustee actually has inherent asset protection in it. And once again, that inherent protection is state by state quite different. So in states like Wyoming, Nevada, South Dakota, Delaware, you have this discretionary interest protection, which says if it's a discretionary interest, and let me take a step back. Discretionary interest, a good way to compare this is to a mandatory trust distribution. So mandatory being Johnny should get $100,000 every year. That's a mandatory distribution versus the trustee may give Johnny money for his well-being, which would be discretionary. So you have these states like South Dakota, Nevada, Delaware, who have enacted legislation that says that's not a property right by definition. It's a mere entitlement. So even if you get a judgment in divorce and they try to enforce that in South Dakota, for example, they wouldn't be able to because there's no property right to actually enforce against anything. So it's another tier of asset protection that you get that you may not have in your respective home state. And I think it's important to note that quickly, because that is a big concern for a lot of families, a lot of family businesses, is creditors, and not just creditors from the operation of the business, but who's your new family, who's marrying who, and how's that going to play, and that's one of those major uncertainties we talk about. So all that being said, we get it. There's third-party trust, there's self-settled trust, there's some asset protection in there. What's the trust design that we oftentimes see for family businesses? And in the next slide, we'll see, but it's directed trust, right? And why? Why directed trust? It's really this quote unquote open architecture that it provides. And by open architecture, it means your advisors that you have in place today, the family members who are in place today, typically continue their roles, even though these assets are going into the trust. And it allows for collaboration between beneficiaries, advisors, grantors, parents, grandparents, so as much as any given family wants to do. And it also allows, and I'll point this out specifically, active family and family advisor involvement. So that's critical for a lot of family businesses that you can do that. And it creates a tremendous amount of flexibility and control. But we get that, right? But what is it and how does it actually work? So the next slide is kind of the structure, but let's take a step back, because what it fundamentally is doing is just taking what the trustee does, I should say, and carving that out. So what does a trustee do? If you go to a South Dakota Trust Company, and we were a full trustee, or you go to your local bank, I should say, what are they actually doing? There's three big buckets of roles that a trustee takes on. The first is the administration, right? The paperwork. They take custody of the assets, they do accountings, they'll file tax returns, basically what no one really wants to do. That's what one element of a trustee is. It's the paperwork. The second one is investments. So who's making investment decisions? Do we hire X money manager, or do we get real estate, or do we hold our family business under the trust? Investment decisions. And the third one is distributions. So when is Johnny going to get his 100,000 or 500 million or 200 million or 500,000 to start his own business? Distribution decision. So you take all three of those, and that's effectively what a trustee does. And what the directed trust does is bifurcate or trifurcate that, so carve them out, and it allows individuals typically to serve those roles. And so you have an investment advisor, for example, who directs a administrative trustee as to the investment. So hold an LLC. You have a distribution advisor who directs the administrative trustee, the trustee, to distribute out to Johnny for $100,000 for his down payment. And you have the administrative trustee doing an admin in the state in which you want the laws to apply. And that's the critical element, that situs. So I want my trustee in Delaware, so Delaware doing administration there, so Delaware law applies. And so why would you do that? What are the benefits to that? Well, I will say in the next slide, is that the key critical component to that is that it provides a tremendous amount of investment and flexibility, right? Because if I go to a full trustee, if I go to my local bank and they're going to act as trustee, they are very cognizant of this Prudent Investor Act that says I have to have a portfolio that's reasonable compared to another portfolio in a similar place at similar time for the same amount of money. And I need to diversify, et cetera, et cetera. Well, what does that say to a family business? Well, I don't want to hold a family business and have that be the sole asset of a trust, because that may violate the Prudent Investor Act. And where does a tremendous amount of litigation occur? With investments. And so if you go to a full trustee, there's a backlash almost, I wouldn't say a backlash, but there is hesitancy to holding closely held businesses. And that's where the directed trust really sings to a lot of people, right? Because it not only provides the flexibility to waive that Prudent Investor Act, but it also increases the fiduciary liability of that investment advisor when they're directing that trustee. It's a gross negligence, willful misconduct standard, not a reasonable care standard. So they have to do something really bad. They would have to, want to commit fraud or hurt the beneficiaries on purpose, lose money on purpose in order to be liable. So that adds to the ability to be flexible, because now I'm not scared of, I'm holding Kodak. I'm scared now of being sued. I don't have that same fear because I have these liability protections. I can waive the Prudent Investor Act, and the corporate fiduciary, that administrative trustee in the state in which you want your laws to apply, also isn't afraid of it, because they're held to a gross negligence, willful misconduct to take the direction from that investment advisor. So you do all of this and you can be as broad as you want. You can invest in alternative investments. You can do real estate. You can hold just a family business. And it's all of that kind of creates this perfect storm, and why we see a lot of families with closely held interest using these directed trusts. And we do this almost exclusively as a trust company. So we know it, right? It's 99% of the trusts that we administer are directed trust. And it really sings to a lot of people. Now, let's take a step back and who usually actually serves in these roles, which it'll lead into the next slide a bit. But who is doing the distribution advisor role? In all these roles, they're usually individuals, right? You don't often, for more complicated planning, you may need an entity, but for the most part, they're individuals. And the distribution advisor role is one that you may need to be a little careful, because there may be tax sensitive distributions that we won't get into now, but oftentimes you may need an independent there. Maybe the trust company that you have administering your trust will do that. Maybe it's a business partner, maybe it's extended family, but usually you want to kind of avoid the grantor at all costs, and subordinates to the grantor. There is some nuance there in planning that you can do, but for the most part, that's how it works. And then for the investment advisor, let's clarify this, is not your money manager. It's not X institution. That's oftentimes really, really confusing to people. It's usually a human being. It's usually the grantor or a family member or a child, a beneficiary, who's actually in that investment advisor role. And they are directing that trustee, that administrative trustee, to take certain actions. So they'll say, South Dakota Trust Company or Delaware Trust Company, you hold an LLC, or open up a brokerage account with X financial institution, or hold real estate. And that's their sole function. They're not typically involved in the day-to-day investment decision-making, because there's an add-on that's oftentimes created in these directed trust structures, which is to create effectively a holdco. And when you look at that, it's, on this page and the next page, we're going to call it, and we can switch to the next slide, we're going to call it an investment management LLC, but I like to think of it as a holdco, right? There's the sole asset of a trust could be an LLC, and that's manager managed, and which state you pick that is oftentimes depending on asset protection. But aside from that, you pick an LLC, and all the various assets of the trust can be under this manager managed LLC. And why is that important? Next slide. Why is that important is because it gives a lot of flexibility as to the types of investments without involving that corporate trustee. So I don't need to have the investment advisor direct South Dakota Trust Company or Delaware Trust Company to hold to do X, Y, and Z all the time. They take one act. They say, sign an operating agreement, appoint X, Y, and Z as managers of that LLC, and then the day-to-day investments of the LLC are done by those managers. So the managers will decide, I want to hold the family business that we have. I want to appoint these people to do X, Y, and Z in the operating business, or have it even go have another hold co that then handles all of that, or have real estate in a different LLC, or have a brokerage account here, and all that's happening under this LLC level. And the key for that is that it provides a lot of flexibility to the families, right? The grantor can get involved with this. They can be one of the managers. They can be managers with their young children, or I should say, say they're in their 20s and 30s. They're learning about finances. They're learning how to operate the trust and the various assets. Well, that can be great proving grounds. Some will split it out. Maybe you have more Gen Z millennial beneficiaries, and so you carve it out. Maybe they want to do impact investing because that's what is hip with the kids in some places. Maybe they want to do real estate and have the day-to-day real estate handled under an LLC, and that can be handled separately as under that LLC or under another LLC. But the fact of the matter is you're not involving that corporate trustee at the top. You don't have that investment advisor sitting there every day having to direct that person to do X, Y, and Z. It's all happening the day-to-day at that manager level. And it creates this ease of management and ease of administration that I will say it's a two-level, right? Because you're not involving the corporate trustee. I keep saying that, but it also can lower fees significantly. It can, because usually how a trustee looks at things is each asset at the entity level, or the trust level, I should say, it adds another, say, $1,000. If I have everything rolled up under a holdco, so the only thing this trust is holding is a manager-managed LLC, you can cut dramatically, no matter if I've got private equity or hedge funds or real estate or privately held business. And so that's a really neat structure and an add-on that we oftentimes see. And it leads us to another add-on that Will's going to talk about, which is a trust protector that we oftentimes see with our directed trusts.
Yeah, no, well, thank you. Thank you very much, Mario. And again, thanks to Pat and Family Enterprise USA for having us present. Certainly happy to be here. Yeah, so in addition to bifurcating or trifurcating the traditional trustee role as Mario was describing, oftentimes we do see in the modern directed trust what's called a trust protector, which really provides even greater flexibility, for the client. And as you can see at the top, top here is the kind of the trust protector. It could be family, friends, or other family, advisors. And really how I would describe a trust protector is, a third-party decision maker who's given the power to make, non-administrative decisions relating to the trust. And many of these powers are not otherwise inherently, a trustee power or trustee role. And so they're a little different than the investment advisor committee or distribution advisor committee, because those are typically the, a trustee role or power. Whereas the trust protector, this is another third party that's added that got some powers that again are defined in the trust document, non-administrative, and typically not inherently a trustee power. Now it's kind of interesting, just to give you some background, the trust protector concept was not, it's relatively a new concept and not known domestically in the US until really the mid 90s. And Jim can attest to this because he and our co-founders were at South Dakota Trust Company and our other colleagues were in a meeting with some international attorneys, and the attorneys mentioned that they were going to draft in the trust document a trust protector. At that point in the late 90s, that they all looked, our colleagues all looked at each other in the room and said, well, what's that? Well, the international attorneys went back and they explained what a trust protector was and what they do. And so our colleagues did their research and In 97, they passed a statute in South Dakota, which was the first trust protector statute in the U.S. After hearing about it from these international attorneys. So it's kind of interesting how the trust protector concept came about and how we got our statute there in South Dakota. But we were the first trust protector statute here. But now flash forward to 2023. And the trust protector is, we're seeing drafted in almost all of our, modern trust documents that we review. And, as Mario mentioned, we review, trust documents quite, all the time. And I'd say the trust protector role does, continually evolve. And it's important to note that, the trust protector's roles, its powers, its duties, vary depending on the governing state law of the trust, and that state's corresponding trust protector statutes. And it also is, it varies based on the individual trust instrument and how it's drafted. But here are some of the powers that the trust protector.
Well, can I just say one thing? We did
Yeah.
have a question on trust protectors. There were a few questions as there seemed to be a lot of interest in how they do it. And I think the powers are pretty great, but on the slide before, I think you had a bullet point on successors. And there was a very interesting and somewhat difficult question asked in our prior comments on, how do you name successors? And certainly we think the first generation successor is someone who typically knows the grantor. They know the grantor's values and what they want. But the question then even asks a little further as well, these are perpetual trusts. They can last a very long time. How do you plan for successors down the road? And there's a lot of family governance that can be had within this trust structure also. So you could do mission statements and family constitutions that really try to pass on the family's values. For specific trusts, a grantor can do a letter of wishes that once again also outlines the goals of the trust and once again the grantor's family values that they hope to gain by using this trust. And all of that is wonderful guidance to future trust protectors that may not know the family now. But I think a lot of the goals are to transfer the values, who the people who created the business, what values did they have when they do it, and what do they want to continue? And that's some of the flexibility that a trust protector can offer. Certainly, I think we'll look at, if there's, someone becomes, addicted to drugs or things, there are ways to cut things off. Things like that may seem more straightforward than, how else do we, create the family value plan within this trust that's going to last forever? And who do we know, 100 years from now will be the trust protector of this? So I think there are ways to build that into both the trust document, outside documents, overall family governance and constitutions to try to have the people who you appoint maintain your values and then pick people who will have those values in the future. It was a very good question, and it's not an easy question, as once again, it goes back to kind of the reasons we started here. There's so much uncertainty in the world, but a trust protector, as Will could see on the other sides, can help, make changes in the future where they're necessary. And then the family and the grantor can try to, put in writing their family beliefs and their family values that can go forever into the future with regards to the trust.
Yeah, no, great point, Jim. Yeah, and I was going to mention as well, really in all of these roles too, that, the roles that Mario was mentioning and with the trust protector role, a lot of clients do come to us and they say they have concerns as to who they want to name, even initially. And, if they may not have somebody that's willing to serve at the current time in those roles. And, I just wanted to mention too, that's, it always, these various roles could be left vacant to, initially as well. And so they could have, then typically for the investment fiduciary and the distribution fiduciary, those powers would default to the trustee. The trust protector, that would just be, they couldn't exercise the power typically until the, some point in the future when a trust protector is appointed, whether the client has somebody or if the need arises. So yeah, there's certainly a lot of flexibility here with how you name successors and who is the successor. But yeah, these are some of the powers that the trust protector can have, and I think it's important to note again that these modern trusts are very flexible, and the powers that the trust protector has can vary based upon the specific trust instrument, and they could have all of these powers, or they could have very limited powers to remove and replace trustees, for example. But some of these powers, they can remove and replace trustees. They can change the situs and governing law to from state X to state Y. They could veto or direct distributions. They could veto or direct investment decisions, approve trustee accounts, amend the trust, add or remove beneficiaries potentially, consent to the exercise of a power of appointment, advise the trustee on matters, which is a lot of times that's a powerful power to provide, whereas if there's a corporate trustee involved, so that they can provide some advisement. They could terminate the trust if the trust is no longer necessary for whatever reason, and they can provide direction regarding notification, which I will to qualified beneficiaries, which I will discuss in a minute here. But so yeah, a lot of powers that can be built in with these trust protectors, and so it's just an added layer of flexibility that we're seeing in these modern trusts. And I think that the traditional trust, as you can see, I mean, the traditional trust where there was a one corporate trustee, oftentimes it was still said, how soon can we get the assets out of the trust versus these days with these modern trusts is how long can we keep the assets in, just because there's so much flexibility, family involvement, control, and other benefits from a tax and asset protection standpoint, compared to that traditional older type trust. So clients are really asking how long they could keep the assets in. And here's a list. We wanted to provide just a list of some of the popular directed modern trust states. And remember, there needs to be, a trustee located in the state that's performing the trust administration and administering the trust in order for the trust to take advantage and the client to take advantage of the state's trust laws there. But I'd say really, all of these states, Alaska, Delaware, Nevada, New Hampshire, South Dakota, Tennessee, Wyoming, they're all good states for situsing a client, for situsing your trust. However, there are some, bells and whistles that some states provide that, or there's others that are more advantageous than than some in certain circumstances, whether it's from a dynastic standpoint or from an asset protection or privacy standpoint. But generally speaking, all of these states are, good states for clients to establish a trust. And as you can imagine, really a prerequisite for being a popular, trust jurisdiction is that the state generally does not have a state income tax. And so if the trust is structured properly, they, depending on the assets and the client's, home state, they could potentially take advantage of, the no state income tax of one of these popular trust states. But these trusts also all, as a prerequisite are, they have.
But yeah, so these popular, trust jurisdictions, another part that they have is that they allow for the trusts to last, in perpetuity or for a very long term. And, and that's very, important, for, to be a popular trust jurisdiction, and it's really because clients do want to keep, trusts, they want to keep their assets in trusts and for a very long period of time and last in perpetuity. And they, like Jim was mentioning, they want to take advantage of, their transfer tax exemptions that they've used to fund the trust, and 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 they don't want to have those assets being pulled into a descendant's estate and thus possibly, being subject to transfer taxes again. So they want to keep those assets in the trust. And if you're in one of these jurisdictions, you have the flexibility to be able to do that and take full advantage of your exemptions and not get those assets back out. And of course, this again is flexible. I mean, just because a trust can last in perpetuity for a very long term doesn't mean that it has to be. There certainly are powers of appointment that can be drafted into the trust for beneficiaries, and there could be other options built in, from an amendment standpoint or for under the state statutes. If the trust is no longer, if it's no longer advantageous to have the trust continue, for the family.
Well, we got a question around domicile
And,
to that
and
point.
as
So,
in
Will,
talking
can you
about
hear me?
dynasty trust planning, we really wanted to provide, some of the perpetual trust structure designs that we typically see. These are really the three common scenarios that we see with these perpetual trusts. And the first being probably what we see when a client is not ready to transfer a large portion of their assets to an irrevocable trust for the benefit of their children or other descendants. And as you can see here, so, in this scenario, pretty much what a client would do is they would, transfer whether it's a family business or other various assets into their will or their draft their will that these assets would pour to a nominally funded revocable living trust at their death, which would then have dynasty trust provisions. So that would be a common, scenario that we'd see if they didn't want to, transfer the assets into a trust currently. Scenario two there would be really with if they did transfer assets into a dynasty trust right now, they could certainly do that. And you'd still have your New York will, which would then pour, at the client's death, would create their marital trust and their state tax exemption trust. So there's still always necessity to have, an estate planning attorney that's local in the client's, home state. But typically their irrevocable dynasty trust that they gift during their life would be in a state like South Dakota that's got the modern trust laws. And you could take advantage of those exemptions. And the good thing is that, if you do transfer the assets now during your life, any growth on those assets, are not subject to those transfer taxes as well. And scenario three there also is, we just wanted to point out that, an ILIT, which is an irrevocable life insurance, life insurance trust could have, dynasty trust provisions as well. So that's, so pretty much where if a trust was holding life insurance policies, it can certainly transition on a grantor's life. It can certainly transition into a dynasty trust for the benefit of the grantor's descendants, after the grantor's passing. And then it can continue, in perpetuity for the family as kind of a family bank.
Yeah. We did have a question on insurance, a pre-question I just wanted to touch on quickly. With family enterprises and family businesses, insurance can be a wonderful tool to work with. As we know, it can provide liquidity to pay any estate taxes at the time so that the sale of a business may certainly not be required. So life insurance could be used that way. Also in buy-sell agreements with businesses, life insurance could be used. And then also in general, dynasty trust. So within an ILIT, you could have an insurance policy that would pay out insurance typically on the second death when an estate tax is due. And then that liquidity can be used to purchase business assets, and the cash can go into the estate to pay the estate taxes. So insurance is a wonderful tool to use especially for family businesses, as either, something that can maybe able to take care of all of the tax issues or at least a part of it. And then once again, the need to plan for all of that and the tax bill that's due is all, this once again, I'll just say what I said again in the beginning. The sooner you look at that, the better, because as Will said in scenario 2, the sooner you could transfer assets out, you get them out of your estate plus all the appreciation. So looking at all this, all of this may happen at the same time, but I hope I also addressed the question on insurance.
Great, thanks, Jim. So jumping to, I know we referenced beneficiary quiet statutes, previously that a trust protector can have the power. And so we wanted to, quickly touch on, beneficiary quiet and the flexibility that the modern trust states offer here. So, traditionally, as you all may know, state laws generally require that a trustee must provide a beneficiary notice and or other information when an irrevocable trust was established, for their benefit. And as you can imagine, there are many reasons, which I will talk about in a second, as to why a client may not want to notify a family member that that they are a beneficiary of a larger family trust. Certainly, if they're gifting the assets, during their life to a trust for their descendants. But to elevate, that concern, most of the modern states enacted these statutes that provide that the trust can specify that notice is no longer required, and it provides flexibility as to, how when you need to notify beneficiaries of the trust existence. So it allows the grantor to select, which beneficiaries and when, will receive trust information. Even if they received a distribution, they wouldn't necessarily have to be provided any information other than the check. After the grantor's death or incapacity, it still could be quiet, and it could be left, as we were referred to earlier, to the trust protector or some other fiduciary under the trust document. And so it doesn't even, some states do limit it to to an event in the future, but in states like South Dakota, there doesn't even need to be limited to a period of time or an event that may happen in the future. And these are really some of the common reasons for that quiet trust. And again, it's some clients will come to us and they want the beneficiaries to know that there's a trust out there, an irrevocable trust for them. But the important thing just to keep in mind is there is this flexibility if there was a beneficiary that was financially not financially mature yet, or they had the trust baby syndrome, where they were trying to avoid that, where they didn't want the knowledge of the trust to adversely affect the beneficiary and their growth. Whether it's for privacy, they didn't want trust checks or any trust information being sent to beneficiaries that are at, school or colleges, and they didn't want their roommates to see that, or various other privacy reasons, which of course that plays into asset protection, prevent any unnecessary lawsuits, identity theft, family safety, and of course, non-voting, business stock. So those are kind of the major reasons that we do see reasons for quiet trust, but most clients do like the flexibility that if they don't want to have to notify the trust, a beneficiary of the trust existence, they don't have to. Before I turn it back to Jim to talk about private family trust companies, which are also a very unique modern trust structure that provide a lot of flexibility, certainly for assets that are difficult to hold for a corporate trustee to hold, I should say. We wanted to touch on if a client had an existing trust, it's important to keep in mind that existing traditional trust could be potentially updated very easily to one of these change situs and governing law to one of these modern trust states and added these directed trust and other advantageous trust provisions that those states provide for flexibility. And that can be done really a number of ways, depending on the existing trust document, whether there's an amendment power, but typically if there isn't that flexibility already in the traditional trust, then there is a possibility that you could change situs governing law from that existing state to a state like South Dakota, and you could take advantage of their favorable and flexible reformation or modification statutes or decanting statutes, which is really where, if you think of decanting a bottle of wine, it's where the assets pour from an old trust to a new trust that's got these updated, modern, and directed trust and other favorable trust provisions. So we just wanted to really touch on that with these, even with an existing trust that's in a state like New York or California, there's still a possibility to update the trust to be very modern and flexible for you and your family. Now to turn it back over to Jim, talk about the our private family trust companies, and again, these structures too are very favorable for the types of assets that that are. But I'll let you talk about that, Jim, I guess a little bit more.
Yeah, thanks, Will. Just quickly on this is just another option to the directed trust. I think a directed trust solves a lot of problems, but for ultra high net worth families that want even more control than a directed trust can give you, we've worked with families and family offices that want to set up their own private trust company. And so that is basically a family owned and operated entity. It's in a state where it gets trust power, so it could act actually as the trustee for the family. So for example, if some families have, 20 to 50 to 100 trusts within the family, where it may make sense for them to create their own trust company. If you go to the next slide, Will. So basically, like I said, it's an entity. It has a board of managers. It's responsible for investments and distributions, and then that entity would act as trustee of the family trust. That family trust then would own as the asset of it a family business. Once again, from holding a single asset such as a family business, it takes a lot of risk away from the family. So once again, just another trust structure that offers families flexibility if they want to create their own specific entity, or they have some reason to create that entity specifically for them. As I'll just kind of wind it up quickly here, because I think what we tried to deal with here are what we found are the three main concerns of family business owners: control, asset protection, and taxes. And we think a directed trust addresses all of those. Once again, you have an investment committee that will direct the trustee to hold either a portion of the business or a non-voting portion of the business, or an LLC that they are the manager of as a whole co, like manager said. So it handles control. Trusts are extremely strong asset protection vehicles, whether they're a third-party trust with a spendthrift provision, or they're an asset protection trust for the family if they want to have the grantor as a permissible beneficiary. And lastly, as we talked about taxes, $13 million today going down to $5 or $7 million by December 31. That's a big difference. That's a lot of wealth that you could start to transfer now. And if you don't do it, you're going to lose that option. So we really think a directed trust really hits on the concerns and issues of family business owners. That's kind of all we had. I'm not sure. We tried to answer some of the pre-questions during our presentation. Certainly, if you have others, you could let Pat know, or you could let us know. Or I think we have 1 minute left.
If you have any questions, I think we said this in the chat. You can put it in the chat in the Q&A. Don't see any in there. I had a question I tried to ask Will, but I don't think he heard me or could hear me for some reason. My question really relates to domicile of assets, which one of the registrants asked for. You talked about these various states where they have specific trust laws that are probably more friendly to individuals. Alaska, certainly South Dakota, various states. If you domicile the trust in those states, do you have to have your assets domiciled in there as well? And the question that asked by the registrant was, how easy is it to move trusts from one domicile to another? So maybe in a minute you can try and answer those
I think
questions.
the easiest almost kind of analogy is like a lot of people will create a business and it'll be owned by a Delaware LLC. So I may be in New York, which doesn't have good LLC laws, so I'll create a Delaware LLC to be the owner. So there is some, the person does not need to be there. The benefit of being as in the state, as Will said, like South Dakota Trust Company, we have 110 people within the state. The trust company, we have the building there, so we are there. The trustee is there. The asset is typically an intangible asset. So a stock, a bond, or business interest, a share in that corporation is an intangible asset. That asset would then be assigned to the trust. So the asset would be within that state because the owner is in that state as the trustee. So the asset can be moved most often in an easy way. Certainly real estate, a lot of times we'll look to put the real estate in an LLC and move the LLC interest. So it really depends on the asset, but it's usually not an issue.
Well, I appreciate that. And I appreciate all of you on this webcast today. I certainly want to thank our panelists who I know put a lot of effort into this presentation. They're all clearly very expert in their field. We really want to thank South Dakota Trust for being a sponsor of Family Enterprise USA and supporting our work. So once again, Jim, Mario, Will, thank you so much for presenting today. I think it was very, very informative for all of our listeners. Everyone, thank you for joining and have a good rest of your day. Take care.